Variety has just dropped a bombshell investigation into Prince Harry and Meghan Markle's.
He's had enough. He wants to clean the monarchy, and it's all now in the hands of the courts. Meghan Markle is in full mode panic along with Harry because they both know what they did.
Prince William has drawn a hard line, and it cuts straight through Meghan Markle's entire maternity story. While Meghan was busy filming TikTok-style dances inside a hospital room and dropping them on Instagram for attention, something far more serious was unfolding in a courtroom across the ocean. A legal storm that she probably hoped would stay buried suddenly stepped into the spotlight. The issue was not small or symbolic. It involved a massive $157 million inheritance battle, a surrogate-born aristocratic child, and an old 400-year-old rule that raised the very question the palace had quietly avoided since 2019. Were the Sussex children actually born of the body? If not, and more people are beginning to ask exactly that, then this is not some minor wrinkle in the royal line. It is a full constitutional problem waiting to erupt.
Maybe King Charles didn't want to do anything about it given what's going on with Andrew, but in order for William to save the monarchy, he has to deal with the Archie and Lilibet problem.
Only days ago, one of the biggest legal shocks in British aristocracy landed, yet almost nobody in Meghan-focused circles broke it down properly. The Marquess of Bath, Sealyn Thin, walked into Bristol High Court with his lawyers and revealed something explosive. His second son, 9-year-old Henry, born through surrogacy in West Hollywood back in 2016, might not even qualify as a legal heir to the family fortune. Around all of this, the noise surrounding Meghan's children has only grown stranger, with people making extreme claims and saying the children are fake or even AI. That atmosphere of suspicion is exactly what gave this court case even more force, because it suddenly made what many dismissed as gossip feel tied to a real legal question.
People think her kids are fake. They think they're AI.
I'm going to quote Tom Bauer by saying, he said, look, we all laughed at Samantha and she was right. And everything she said has come true.
This is not about pocket change. $157 million is locked in old trusts written in outdated language from before 1970. Under those rules, if a child is not physically born from the mother, the system effectively does not recognize that child in the same way. It is that strict. No soft interpretation, no modern adjustment, no easy workaround built into the old wording.
Something is happening right now in the courts, which is incredibly important, and nobody's paying attention to it because this will make history, and not in a good way for Rachel Meghan Markle.
Mr. Justice Matthews did not dress it up or soften it. He said plainly that there is uncertainty over whether Henry even counts as a beneficiary. Think about what that means. A 9-year-old boy, fully biological to his parents, born through a completely legal and documented surrogacy arrangement, can still be left standing outside the door of recognition because the system says it is not sure he qualifies. That is where the matter stops sounding theoretical and starts becoming serious. That is also the point where attention shifts toward Montecito, because the resemblance to Harry and Meghan's situation becomes impossible to ignore.
Trevor put an article out there that Meghan had a hysterectomy and couldn't have children, and that was a big issue in their relationship. So that says a lot to the fake royal kids right now, because obviously they couldn't have come out of her. So that's something that she obviously is going to have to deal with.
This is where things begin to heat up for Meghan and Harry, because the case lands far too close to home. The royal line of succession is built on one old, rigid rule: born of the body. That phrase has governed the system since the Act of Settlement in 1701. More than 300 years of tradition rest on those words. There is no room in that phrase for flexibility, no exceptions written into it, and no casual rewriting of what it means. That standard has sat at the center of royal succession for centuries.
She had a lot of health issues and she couldn't have one of her children. So they had to use a surrogate in the United States. Why the United States? Because in the United Kingdom, the children, even though through a surrogate, belong to the surrogate.
Every royal heir before this followed that same structure. Palace officials witnessed the process. Everything was carefully documented, everything was checked and confirmed, and no shortcuts were taken. Then Archie arrived, and suddenly the old playbook looked different. This is not being framed as simple dislike of Meghan because of online noise. It is being framed as a pattern. one that keeps returning whenever her pregnancies and the births of the children are discussed.
The Marquess of Bath was open and transparent about this. So she is right now going through the legal process because as per the Peerage Act of 1963, that child born in the United States from a surrogate is not entitled to anything, inheritance or anything.
The same Meghan who sat with Oprah and spoke about living authentically is also linked to a team that pushes back hard whenever basic questions arise about her pregnancy timeline. People ask simple things and legal warnings start flying. That does not come across as openness. It comes across as image control dressed in royal language. The issue here is not supposed to be wild theorizing. It is supposed to be clarity in a system where bloodline determines everything. The questions themselves are direct. Where were the children born, when exactly were they born, and who verified it? There was also that public moment when people were asking who Archie took after and whether anyone could tell yet. It was said that the baby had changed so much over 2 weeks and that his looks were changing every single day, so nobody could really know. Set that beside William's children, all born at St. Mary's Hospital and presented on the steps within hours, fully documented in full view of the public. The entire country could watch those moments unfold in real time. That is the comparison many people keep making, and that is where the raised eyebrows begin. When Archie Harrison Mountbatten Windsor was born at Portland Hospital on the 6th of May, 2019, nothing followed the normal royal script. There was no hospital steps photo call, even though that had been a tradition for decades. There was no sign notice from attending doctors posted publicly, even though that had always been standard practice. Meghan Markle remained extremely quiet, not only about the birth itself but especially about the pregnancy. The whole thing came across as shaded in secrecy. The one who kept speaking and making startling claims was Prince Harry. Yes, a birth certificate was released, but for many people it did not answer everything. Harry later wrote in Spare that they left the hospital within 2 hours, went straight into a lift down to an underground car park, got into a vehicle and were gone. Back to Frogmore Cottage before the palace had even officially confirmed that Meghan was in labor. For a family that had spent centuries making royal births transparent for constitutional reasons and not merely ceremonial ones, that was not a small deviation. It was a total break from tradition. People remembered the clear hospital photographs from William's birth and Harry's birth, and later from George, Charlotte, and Louis. William and Catherine were seen as making a real effort to show the whole world their new baby. Against that backdrop, Harry's own description of Archie's arrival did not read like a formal royal record at all. He spoke about electric candles, framed photographs of Diana, and an Ayurvedic doctor guiding them to whisper wishes to the baby in the first minute of life. It sounded deeply personal, and no one could deny that, but it also felt far removed from the structured, documented process royal watchers were used to seeing. Other royals gave a clear birth announcement. Harry gave something that sounded much closer to a lifestyle story. Then came Lilibet in June 2021, and the questions did not die down. They doubled. Meghan had reportedly refused to use the hospital usually used by royals, and had also refused the normal medical staff. There had already been oddness around the timing of Archie's birth, and now Lilibet was born at Santa Barbara Cottage Hospital under another cloud of uncertainty. Harry wrote that he personally delivered his daughter, saying he slid his hands under the tiny back and neck and pulled their precious daughter from that world into this one. It sounded powerful and intimate, and no one questioned a father wanting to be that involved. But that is exactly where the larger issue sits, because in a system where the rules around birth and verification still matter for succession, those details are not just private family memories. Harry's version in Spare described how complicated it all was, how they went to the hospital, and how Meghan had to have 2 epidurals. In the transcript, those claims are rejected outright as false, and that rejection is tied directly to the broader question of trust. In a structure where proof of birth and proper verification still carry constitutional significance, these are not small personal details that affect only one household. They carry weight far beyond Montecito, ignoring that reality only causes more people to ask more questions. Unlike every major royal birth reaching back to the early 1700s, neither Archie's nor Lilibet's arrival was independently witnessed or formally verified by palace-appointed officials. Not one, no independent medical witness, no traditional Privy Council-style confirmation, only Harry's personal account. That is why the scandal is described as unsurprising. Speculation about the children has been simmering for years, and when those children are 6th and 7th in line to the British throne, a personal story, however heartfelt, is not the same thing as an official constitutional record. The part that continues to trouble people is simple. If there is nothing to hide, and perhaps there is not, then why has there not been one clear and simple confirmation in 6 years? Why not silence everyone with straightforward proof, whether a DNA sample or proof of delivery? If those things exist, it should be easy to put them forward and say plainly that this is what happened. Instead of that, what people have seen are legal warnings, layered statements, and indirect answers. A basic question has kept receiving complicated responses, and that alone has kept the story alive. Reports from well-placed sources suggest that Prince William has taken the circumstances around both births seriously. One insider said he views the situation surrounding those births as unusual. That is not the kind of word someone in his position is expected to use lightly, and the argument here is that his actions seem to reflect that mindset as well. There has been what many describe as a noticeable effort to separate the Sussex name from the monarchy's official structure. From changes in royal listings to continuing conversations about how titles are being used, especially in commercial spaces. A broader frustration keeps surfacing around that same point. Prince William is seen as understanding that the crown cannot go on repeating the same mistakes from the past, and that nobody who is not a working royal should continue holding a title in that way. One comment captures the tension directly. If Meghan hates the royals so much, then she should stop using the title they gave her. That contrast is what stands out to many observers. Stepping back from royal duty while still relying on royal identifiers in public-facing projects is the thing that keeps the conversation alive. That is why the Marquess of Bath case matters so much in this moment. What once felt theoretical is now being treated like a real legal question. There is a growing view that King Charles still does not fully grasp that Harry and Meghan cannot continue appearing on the British monarchy's website, while also attacking the very institution and using their titles for commercial purposes. To some critics, that looks like the same old pattern seen before with Sarah Ferguson and even Andrew, and they say that pattern has to stop. At the center of the Bath case, however, is a father who clearly cares about his son, has been open about the surrogacy, and is actively using the courts to secure his child's place. That is presented as a parent standing up and dealing with the problem directly. The key point his case brings into focus is simple. Under current British inheritance and trust law, especially older law, uncertainty can still exist over how surrogate-born children are recognized in specific legal settings. This is not being framed as opinion. It is being framed as the law exactly as written. That same frustration feeds directly into the criticism aimed at Meghan. The accusation is that she wants every privilege attached to a particular identity but does not want the responsibility that comes with it. She wants the tiara but not the public service. She wants the status but not the work. Against that backdrop, Mr. Justice Matthews made it plain that the Marquess had to go to court and formally ask for Henry to be added as a beneficiary. The law was not going to do that automatically. That is the part the argument keeps returning to. A father has to stand before a judge and ask for his own child to be recognized under the system. That is how strict and outdated some of these rules still are. Once that is understood, the leap to the monarchy becomes obvious. The conversation is no longer about a private trust. It becomes about the Crown, the Act of Settlement, and the succession to the Crown Act, all of them centuries-old constitutional frameworks that cannot simply be updated quietly in a meeting. These are not minor rules at the edge of the system, they are part of the foundations. The claim is pushed further by invoking the Peerage Act of 1963, described here as making it clear, just as in royalty, that a surrogate cannot be used. If a $157 million estate can run into genuine legal uncertainty because of a surrogate-born child, then the natural question becomes much larger. What sort of questions could arise around an institution that is more than 1,000 years old? That is where the subject becomes deeply uncomfortable. If, and the wording remains careful on this point, it were ever formally confirmed that surrogacy played a role in either of the Sussex children's births, then the consequences would not remain private or symbolic. It is even claimed that William has ordered an open investigation into Archie and Lilibet's births, because he knows that uncertainty of that kind cannot hang over the monarchy or over his future reign. From there, the next question follows immediately. Would Parliament have to step in and examine whether the children's places in the line of succession meet the current legal definitions? Because the Bath case suggests the answer may not be as automatic as many people once assumed. That is why this stops being just a dramatic headline and starts being presented as a real legal problem. Comments that were brushed aside before are being revisited in a different light. Earlier favorable remarks were ignored, while silence itself gave other people space to create stories. Now even simple statements telling people to look at the timeline are being given renewed attention, not merely because of who said them, but because of what is happening in court right now. The focus has shifted. What looked like pure speculation to some now appears to others as something tied directly to legal wording and legal precedent. It is no longer just a clash of opinions. It has become a question of how existing law is written and how that law is applied. This is also where a wider character judgment is folded into the story. There are said to be so many examples that it would have been easier simply to be honest from the beginning about who she is. The argument goes further and says that all of these lies started coming out later, though people did not yet know that she had told the royal family so many falsehoods. That in this framing explains the intense effort to keep everyone at a distance. If people start talking, then the lies come out. That is how the pattern is described, almost as something predictable. But whatever people think about those claims on a personal level, the legal side of the matter is what gives them renewed force now. Attention has turned back to phrases like born of the body, and people are asking how consistently that standard is applied when different situations arise. That question matters because the same wording can throw one child's inheritance into doubt in one case, while leaving people wondering how it operates somewhere else. Curiosity grows naturally once that happens. It is not being presented here as rumor for its own sake, but as people examining legal language and precedent. When an old legal formula is still powerful enough to determine whether a child is recognized as a beneficiary, it becomes impossible to stop people from asking what that same formula means for a royal succession line. The issue is not just emotion, appearance, or public image. It is consistency in law. The lack of detailed public clarification has only kept that conversation alive. When the questions first began circulating, the responses focused more on privacy and on controlling media coverage than on offering detailed public verification. That may be understandable from a personal point of view, but it also left many observers feeling that the central questions were never answered in a direct and final way. The result is that silence itself became part of the story. Every careful statement, every indirect response, and every refusal to provide simple confirmation created more room for doubt instead of closing it down. The more tightly the matter was handled, the more people felt there was a reason they were not being shown the full picture. An important contrast also keeps returning. In the Bath case, everything is being handled openly in court. There is a visible process, clear arguments, and full transparency around the dispute. Whether one agrees with the outcome or not, the matter is being dealt with directly. That openness stands in sharp contrast to the Sussex situation, which has remained far more private and has offered only limited official detail to the public. People continue to point to that difference. On one side, the issue is taken into court and argued plainly. On the other, the matter is surrounded by privacy, personal accounts, legal pushback, and unanswered questions. Prince William did not create any of these questions, but he is in a position where clarity matters more than ever. From what can be seen, there is an effort to make sure the monarchy's future avoids uncertainty, especially on matters that carry constitutional weight. This is not being framed as drama for drama's sake. It is being framed as stability, continuity, and protection of the institution. At the end of it all, the discussion keeps circling back to the same point: consistency. How rules are written, how they are applied, and how clearly they are communicated. The Bath case has shown that even very old systems can be challenged by modern realities, and once that happens, people do not stop at the first question. They start asking larger ones. Prince William is said to have taken the circumstances around both births very seriously. According to well-placed sources, he sees the situation as unusual, and that is not a word someone in his position would be expected to use casually. The sense around him is that clarity matters, because the monarchy cannot afford unresolved questions hanging over issues that touch the line of succession. That concern is also reflected in the way the Sussex name has increasingly been separated from the monarchy's official structure. People point to changes in royal listings and to the continuing debate over how titles are used, especially when those titles appear in commercial settings. The frustration many observers express comes from what they see as a contradiction. Harry and Meghan stepped back from royal duties, yet royal identifiers still remain attached to public-facing work. That contrast is one of the main reasons the conversation has not disappeared. A lot of criticism is tied to that same point. Some believe the crown cannot keep repeating mistakes from the past, and cannot allow people who are no longer working royals to keep benefiting from royal titles in the same way. One blunt view of the matter is that if Meghan dislikes the royal institution so strongly, then she should stop using the title that institution gave her. That feeling is not presented as isolated media noise, but as part of a much broader unease about responsibility, privilege, and public presentation. The tension becomes stronger because the image projected outward does not always match the stance taken toward the institution itself. This is why the Marquess of Bath case suddenly became so important. It took something people had been treating as a remote or theoretical concern and turned it into a live legal question. There is also growing criticism of King Charles in this context. Some argue he still does not fully understand that Harry and Meghan cannot remain on the British monarchy's website while also attacking the same institution and using their titles for commercial purposes. To those critics, it looks like a repeat of older patterns seen with other royals who blurred the line between royal identity and personal advantage. In that reading, the pattern has to stop. Set against all of that is the figure of the Marquess of Bath himself, who is described as a father openly dealing with the issue. He has not hidden the fact of the surrogacy. He has not tried to bury the legal question. Instead, he has gone through the courts to secure his son's position. That is presented as direct action, transparent action, and parental action. His case matters because it shows that under British inheritance and trust law, especially older law, uncertainty can still exist over how surrogate-born children are treated in highly specific legal contexts. That uncertainty is not being framed as an emotional or moral judgment. It comes down to the exact wording of the law. The complaint aimed at Meghan in this wider discussion is that she wants all of the privileges attached to a royal identity without accepting the responsibility that comes with it. She wants the tiara but not the public service. She wants the image but not the work. The point is sharpened by what happened in court where Mr. Justice Matthews made it clear that the Marquess had to formally ask for Henry to be recognized as a beneficiary. Nothing was automatic. The law did not simply move with the times on its own. A father had to stand before a judge and ask for his own child to be acknowledged by the system. That is how rigid and outdated the framework still is. Once that reality is accepted in the case of a private fortune, the implications become much larger when the same principle is considered in relation to the monarchy. The conversation stops being about one trust and starts touching the Crown, the Act of Settlement, and the succession to the Crown Act. These are not modern policies that can be adjusted quietly behind closed doors. They are old constitutional structures that form part of the foundation of the monarchy itself. The argument becomes even more forceful when the Peerage Act of 1963 is brought into it, with the claim that just as with royalty, a surrogate cannot be used. If a $157 million estate can be thrown into legal uncertainty because a child was born through surrogacy, then people naturally begin asking what happens when the same kind of question is placed against an institution more than 1,000 years old. That is the point where the subject turns uncomfortable very quickly. If it were ever formally confirmed that surrogacy played a role in either Archie's or Lilibet's birth, then the consequences would not remain limited to gossip columns or online arguments. The question would become constitutional. The suggestion is even made that William has ordered an open investigation into both births because he knows that uncertainty of that kind cannot remain hanging over the monarchy or over his future reign. If such confirmation ever came, Parliament itself could be forced to consider whether the children's places in the line of succession meet the legal definitions currently in force. The Bath case has made that question feel real. What once sounded like speculation now sounds, to some, like a matter of statutory wording and legal application. That shift is why older comments are being looked at again. Statements that were ignored before are now being revisited under a different light. Favorable remarks were not given attention. Silence allowed others to create their own stories. And now even simple remarks telling people to look at the timeline are gaining renewed interest. The reason is not only who made those remarks, but what is happening in court right now. The focus has changed. What many once dismissed as opinion or obsession is being reconsidered through the lens of precedent and legal language. The phrase "born of the body" has returned to the center of the discussion, and once people begin examining how it works in one case, they inevitably begin asking how it is applied in others. That is where the story folds back into accusations about dishonesty. The claim is that there were too many lies, and that it would have been far easier simply to be honest about who she was from the beginning. It is said that many of those lies started to emerge later, and that people did not realize at first how many falsehoods had allegedly been told to the royal family. In that interpretation, keeping people away was not accidental but necessary, because once people started talking openly, the inconsistencies would surface. Whether someone accepts that view or not, it feeds directly into the larger legal question, because it reinforces the belief that the truth was never presented plainly. That is why people continue returning to the timeline, the details, and the absence of direct verification. Curiosity does not grow in a vacuum. It grows because the same legal wording can cast doubt over one child's inheritance in one setting, and then leave everyone wondering how far that wording reaches elsewhere. That is not rumor in the sense of random invention. It is a reaction to precedent and to the visible force of old legal language. When people see a child's recognition delayed or questioned because of a rule written long ago, they naturally ask whether the same rule still matters in other institutions built on lineage. Inheritance and bloodline. The issue keeps widening because no clear public explanation has ever shut it down. That absence of detailed clarification is one of the biggest reasons the matter remains alive. When the first questions began circulating, the response centered more on privacy and media management than on offering a detailed and definitive public verification. That may be understandable from a family perspective, but it also left many people feeling that the central issue had never been answered directly. Every indirect statement, every legal warning, and every carefully managed response created more distance instead of certainty. The story did not die because the answers never arrived in a form that closed the matter decisively. The contrast with the Bath case keeps standing out. There, everything is happening openly in court. The process is visible, the arguments are visible, the uncertainty is being addressed through a formal channel with full exposure. In the Sussex case, the handling has been much more private, with limited official details shared publicly. That difference is what people keep pointing to. One situation is being confronted transparently. The other has remained guarded, layered, and unresolved in the public eye. Prince William did not create any of these questions, but he stands in a position where uncertainty cannot simply be ignored. Stability matters. Consistency matters. The future of the monarchy depends on how rules are written, how they are applied, and how clearly they are explained. The Bath case has shown that even old systems face modern challenges, and once those challenges appear, the questions become much bigger than the people at the center of them.